We've looked at the background for the case. Now, let's look at the relevant South Carolina law. Planned Parenthood South Atlantic operates 2 clinics in South Carolina, offering a wide range of services to Medicaid and non-Medicaid patients. It also performs abortions. Citing state law prohibiting public funds for abortion, South Carolina in July 2018 determined that Planned Parenthood could no longer participate in the state's Medicaid program. No one is saying the Planned Parenthood of South Carolina has to shut down their clinics or stop providing abortions, only that they are not eligible for the state's Medicaid program. This is because of a state law that prohibits public funding going to abortion. At the same time, the state took steps that, it said, would help ensure that other providers would continue offering necessary medical care and family planning services. The states did not abandon people seeking medical care and family planning services. The state took steps to make sure they could receive care. That wasn't good enough for Planned Parenthood or for one of their patients. Planned Parenthood and patient Julie Edwards sued, claiming the exclusion of Planned Parenthood violated the Any Qualified Provider provision. Now, however, the state showed that Planned Parenthood was not qualified to accept public funds. They may have been qualified to provide other services, just not with public funds. Edwards alleged she preferred Planned Parenthood for gynecological care but needed Medicaid coverage. They brought a Section 1983 class action to vindicate rights secured by the federal Medicaid statute. The fact that Ms. Edwards prefers Planned Parenthood doesn't mean she has the right to get services from them paid for by the public money. No one in the state of South Carolina is preventing her from getting services from Planned Parenthood, only that it's not paying for their services. Her claimed right to Medicaid funding doesn't include using it at unqualified establishments. Section 1983 allows private parties to sue state actors who violate their rights under the federal Constitution and laws, but federal statutes do not automatically confer Section 1983 enforceable rights. This is especially true of spending power statutes like Medicaid, where the typical remedy for violation is federal funding termination, not private suits. Title 18 of the United States Code, Section 1983, is the law Congress passed affirming a person's right to sue someone for a deprivation of rights under color of law. Now, while the court focuses on whether or not the Medicaid law established rights enforceable by Section 1983, I think there's a more fundamental question. Does Medicaid law create a right for someone to receive medical care at taxpayer expense, whether or not the state lists them as a qualified provider? The district court granted summary judgment for plaintiffs and enjoined the exclusion. The Fourth Circuit affirmed. This court then granted certiorari, vacated, and remanded in light of Health and Hospital Corporation of Marion City versus Tlefsky, which addressed whether another spending power statute created Section 1983 enforceable rights. On remand, the Fourth Circuit reaffirmed. So both the district and circuit courts found for Planned Parenthood, but the Supreme Court vacated based on the case Health and Hospital Corporation of Marion City versus Tlefsky. Tlefsky is a case where the court found that a congressional act did not create a Section 1983 enforceable right. In this case, the court held Section 1396 AA 23A does not clearly and unambiguously confer individual rights enforceable under Section 1983. So this court doesn't think that the Medicaid Act created a right enforceable by Section 1983.